So, hello and very warm welcome to everyone. We welcome you once again to another session of Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the very generous contribution of all of our seniors, guides, mentors who take the time out from their very busy schedules to uh, help us explore different possibilities and opportunities in the legal spectrum. So today we have with us for one such very remarkable session on arbitration, Shri Amarjit Singh Chandhiok, sir. Amarjit sir, I think everyone is very well aware of him. Anyone at least who's practicing law in India knows him or should know him. If not, then I will, irrespective, give a very brief introduction to sir. Shri Chandhiok is a distinguished senior advocate practicing in the Supreme Court and High Court of India. He was president of Delhi High Court Bar Association for a record 6 times. He is a former Solicitor General, Additional Solicitor General of India. Shri Chandhiok was also Principal Counsel to European Union Commission from August 2013 to March 2016. Shri Chandhiok is the president of Madhyam Council for Conflict Resolution, a professional organization aiming excellence in the development of law and conflict resolution. He is vice chairman of Society of Insolvency Petitioners of India and member advisory committee of the Insolvency and Bankruptcy Board of India. So he is also the chairman of the working group under the Insolvency Bankruptcy Board of India. Shri Chandhiok is a member, London Court of International Arbitration, member International Council of Arbitration, accredited mediator of Singapore International Mediation Institute. He has formerly been a member of the ICC arbitral tribunals for international arbitration. He has also appeared before various arbitral tribunals of ICC at various places abroad and has represented the Indian government in the Enron arbitration in London. Shri Chandhiok has been conferred many prestigious awards, including Outstanding Jurist 2000 by J.N. Kaushal Jurisprudence Center, New Delhi, Award for rendering meritorious legal services from Delhi Citizens Forum for Civil Rights in 2002, National Law Day Award 2006 from the Prime Minister of India, Dr. Manmohan Singh, for the contribution made by him in the practice of civil law. The leader in the profession, leader of the Bar Awards 2007 from the Bar Council of India. He's also been awarded 2 doctorates. So again, I've just tried to limit it as much as I possibly can because it's a very elaborate and distinguished list. So I very warmly welcome Amarjit sir, and I hand over the class to him. But it's very interesting that I think I am not being able to find Amarjit sir here right now. So I think we'll just wait a little bit for sir to rejoin the meeting. And in the meanwhile, yeah. So again, so since we're talking about what exactly is the session for today, so we need to keep in mind that there is a lot of change that is happening with respect to the legal framework. There is a lot of emphasis on shift from the original litigation-based practice to a more of a dispute resolution, centric uh, uh, manner of litigation, which would primarily, I think, be something on the lines of how ADR is evolving today with respect to mediations and arbitrations. So it's a very, very fundamental class today, and we have the best of the best person to guide us through that. But I most humbly request you to kindly just bear with us for this technical issue that we've received, and we will just get Amarjit sir back, and we'll reconvene the class. In the meanwhile, I request everyone to kindly just share whatever questions and thoughts you have in the chat box. Also, in the meanwhile, I request that you may kindly just aware yourself that we have classes going on from today, which is the 20th of December, till the 24th of December. So I just request that you kindly check your calendars. All classes are fantastic. All faculties are amazing, and Chandhiok is also back with us. So just be update your calendars and be ready with that. Also, please be attentive for today's class. Amarjit sir, welcome back.
Yes.
So, introduction, sir, I have tried to limit it.
That's fine. There's no need to introduction.
But sir, I most humbly, sir, welcome you with folded hands. And sir,
Thank you so much.
so
Thank
grateful
you.
to you for being you. And sir, I request you to kindly take this last moment.
Thank you, Keshav, for all those kind words. I don't think I need to deserve all that. I can only say that whatever God bestowed on me, whatever the God thought that I could do, it has bestowed upon me, and I try my best to cover it up and do whatever best I can. Welcome all to this session. The Arbitration and Conciliation Act actually forms part of an alternative dispute resolution. When we say alternative, it actually means now in the present terms, appropriate. Alternative ki jagah, appropriate should be the word to my mind. Because what are we looking at? You see, with our population going manifold, not only population, the disputes are going manifold. And the recent phenomena that I see when I even go to schools or colleges, I find even at that stage, there are disputes between teachers, students, teachers and parents. There are disputes, intimacy between the colleagues. In fact, in a recent workshop that we did in Delhi University, for 3 colleges, we were surprised to see that the communication system between children or students was almost negligible. So we try to restore that. So the arbitration is one mode which is prescribed by law, which is alternative to filing a suit or going to a court. It has its own rules, it has its own layout. With the Commercial Courts Act 2015, there have been certain changes in the Arbitration Act also. By virtue of the Mediation Act also, there's some changes in the Arbitration Act. But fundamentally, it means parties are in charge of their litigation. They themselves should be agreeable to appoint an arbitrator and then proceed with the judicial dispensation at the hands of the arbitral tribunal. Now, I understand what Keshav says, what is the challenges before the youngsters today. I appreciate with so many law colleges all over the country, I see between Amity and Greater Noida, there are 41 law colleges. So obviously, India, Delhi would especially have an influx. And while arguing on behalf of lawyers where Delhi government has given a very limited amount for their life insurance and their medical insurance, I've said, why should that 13 or 10 odd thousand students or new lawyers, youngsters who join the profession, should not get the same benefit as somebody else in the profession gets it? So that's a matter pending in court. So the purpose of my speaking to you is this to say, a lot of people feel that we have a lot of challenges. A lot of us feel that we can't really, there's too much of rush in the profession today. There are too many lawyers moving around. You see cafeterias of the courts are full with lawyers. But I can tell you the top is still empty. I do not have, with all humility at my command, I don't have Palkiwala today in the country. I don't have Daftari Sahib in the country. I'm not talking only in terms of lawyer. I'm also in terms of human beings. So my first request to all my youngsters would be, look at your statute, adopt it as if you're adopting your own religion. Go into it, go into details of it. Each word has a meaning. And give it your own meaning before you go to your cloud or your SEC online or whatever you want to use to see what are the judgments. Because your mind will interpret it because you're fresh in the profession. You may look at it when nobody else has seen. And you may bring something new to the court. Therefore, that is the first challenge before the youngsters today, that they may please adopt their minds bestowed on them by God rather than computers or laptops or even phones. Once you read your statute, that's your first challenge according to me. And once you understand the scheme of that law, you will be able to proceed further. And there's nothing detailed about it. You will know the facts from your client, whether you're a claimant or you're a respondent. You'll put them into an order like a story that you tell, place it before the arbitral tribunal. The other side will tell its own story, and then the points of determination will come out. So the challenge that I see today is this, that we are using artificial intelligence for everything. Artificial intelligence is not meant to substitute my brain. Therefore, you need to, and excuse my saying so, I put a question to all of my youngsters: why do I chew my food? I chew it because I must have a good digestive system to digest that food. Similarly, chew your act, Arbitration Act, chew your facts, so that the arbitral tribunal can appreciate your statement of claim or defense, whatever you are, and is able to appreciate what is the point of determination that he actually has to decide. Though there is, I must accept before you all, there's a lot many things going on today to say that arbitration has also been derailed by very huge sums being demanded by the arbitral tribunals. But to my mind, you will still find arbitral tribunals to be constituted who are ready to go by the fee provided by law. And that is where we are stressing that institutional arbitration is the need of the hour today. And speaking for myself, I feel that we should have more lawyers going into arbitral tribunals, because if somebody has done a commercial dispute in the court, for example, it will be easier for him to do so. I'm not saying judges are incompetent, but you see, judge will look at it from the point of view that he has been all that 15, 20 years that he has been at the bar, at the bench, to understand that he will do that. But so question is this only, that we must understand the statute first, its scheme, and then we proceed further to see what are the facts of our client. So when a client comes to you, please get those facts, chew them properly within yourself so that you can digest them well and then make that presentation before the arbitral tribunal. Then comes your art, how you will prove that point of determination. That's another challenge. When people like me came to the bar, trial was a norm, and we used to go to courts to see who is doing trial, how they are conducting cross-examination. Unfortunately, all that has been put into grave because we have started doing evidence by affidavits, and local commissions have started recording it. There is no jurisdiction to disallow or allow. To give you an example, in Delhi High Court, which has original jurisdiction, if the trial used to begin at 12:30 sharp and would end after the trial is over, whether it takes 2 days or 3 days. Every day it will be called when the judgment comes. So the judge used to say, I have recorded the evidence of all the witnesses. I know what all they have said. Please answer these 4 questions and your final arguments are over. But today, because he has not recorded it, therefore it is taking time. Fortunately for us, before the arbitral tribunals, we are still recording evidence. So that disadvantage in the court is not before the arbitral tribunal. So the arbitral tribunal will be able to appreciate what the witnesses have said one way or the other. And you'll have to only point out those paragraphs by which you want your case to succeed. or your claim to be accepted, or your defense to be accepted. So the youngsters must first develop, as I said, a knowledge of the statute from alphabet A to Z. Please also understand when will part 1 apply, when will part 2 apply, what is the distinction between a domestic arbitration and an international arbitration. And in fact, in one of the events that we are doing on 11th of January, a topic has been proposed by me to say that if there's an international arbitration delivered by an arbitral tribunal in Japan, and the enforcement is taking place in Delhi, and the person against whom the award was made in Japan also files a petition to set aside the award. Not rightly or wrongly, the Honorable Single Judge who decided that case dismissed the enforcement petition and allowed setting aside the award. So the award was set aside. So the question that has arisen is, by virtue of that judgment, have you not changed the seat of arbitration also? So all these you will be only able to appreciate if you know the scheme of law. That's why I'm insisting on that and bringing your kind attention to it. When will part 1 apply? When will BALCO apply? The Supreme Court Constitutional Bench judgment comes in. To what agreements would it be applicable? But here I have given you an example which has nothing to do with BALCO or for anybody, for that matter, any other judgment. It's an act of the court, and both parties have accepted that judgment. If you have accepted, how do you go back to Japan? Because part 1 in its entirety has been made applicable to you. To the facts of the case or to the claims that you have made. Your enforcement is dismissed, 34 is allowed, and your award is set aside. However, when you get that liberty to go back to arbitration, the question would be, where do you go? Do you go back to Japan or you can start in India? So these are important questions that you will be able to emerge them out. I can assure you there's no precedent for it today. It's youngsters like you who are brilliant, coming with new ideas, innovating them, have brought this to my notice. And we are now making it go forward. So the question that I'm posing to you is that, A, once you know your facts, what has happened in a particular case and why it has happened. Or take, for example, a contract where the contractor says, I have not breached, the principal has breached because he was not paying me the money. The engineer had already passed my bills, but he was not making payment, and therefore, with that crunch, I was not able to perform. So you will have to bring those fact aspects to that till a particular date, you were performing as per schedule, paying your running bills were going on, and after those running bills have gone on, the person designated, which is chief engineer or whatever is, executive engineer, has approved them, but the employer is not paying. So your point of determination is only this much, that despite the compliance with the terms and the covenants of the agreement, still the employer has not paid. So the breach is on his part. So he should give you the money, he should give you the interest or whatever compensation the arbitral tribunal may give. A lot has been said with respect to how do I file my statement of claim. You see, to me, section 141 of the Code of Civil Procedure says CPC would apply to all civil proceedings. First part. The Arbitration Act, on the other hand, says arbitral tribunal shall not be bound by the provisions of CPC as well as the Evidence Act. So the arbitral tribunal is not bound, but how about you? You are a claimant or a respondent, and there is no other procedure in law. The Arbitration Act says you will make a statement of claim. Statement of claim is nothing else but your plaint, because you'll have to plead all those facts. You'll have to plead your cause of action. You'll have to claim relief. So identically, it is the plaint only, but in a different form. Instead of saying it's plaint, you're saying it's a statement of claim. Nothing more than that. And please consider now that after 2015 Act of Commercial Courts Act, the Code of Civil Procedure has been amended on one end, And Section 10 of the Commercial Courts Act brings arbitration within the Commercial Courts Act. So the question would be a subsequent statute, which is Arbitration and Conciliation Act 1996, whereas the Commercial Courts Act is 2015. What prevails? The answer is only the letter will prevail. And if the letter has prescribed a particular procedure to be followed by you or filed by claimant or respondent, then there has to be need to be followed it. In fact, I'm very happy to tell you that today, when as an arbitrator by me or by all other arbitral tribunals, when they have seen these pleadings completed, what do? They say you will file an admission denial of documents in terms of the affidavit prescribed under the Commercial Courts Act. Because there you have to give a reason. If I deny something, you have to give a reason. Why am I denying it? Simple denial is not sufficient. I have to give a reason for that denial. So all these statutes are actually together. A bunch of statutes help you to develop your forte for an arbitration. In arbitration, you can start with domestic, you can go to treaty arbitration, you can go to international dispute arbitration. There are so many things that are happening in the world today. In fact, we see Enron, if most of you would have heard it, if not been a part of it. It was an investment into this country. The investment failed. So they invoked the treaty arbitration. And we took an objection that look, you are an investor into a company like any other investor. It's a business deal. And you cannot invoke treaty arbitration for a dispute in a commercial dispute between the parties. And there that was, that we succeeded. The parties came to a settlement and we settled the dispute. So I am only requesting you to first learn what is the statute A. Whenever a case comes before you, as I said, and for the sake of repetition, I'm saying, chew the facts, see which part of law would apply to you. How do you go about your statement of claim or defense, as the case may be? What all you should deny and what all you should admit. In fact, in most of the time, especially in the commercial contracts, you don't need oral evidence unless there is something more to what has happened between the parties, because you're governed by the terms of a contract. Everything is, your running bills are already admitted or gone to chief engineers, accepted. But there could be a situation where you need an expert in the field to look at your facts and give evidence in your support to say, yes, these machines were not working, they are defective. And why they are defective? And you may not be able to point out what are those defects. So there's a specific provision under the Arbitration Act when you can call an expert, engage him, give him that assignment, and he gets examined before the arbitral tribunal to give evidence with respect to the fact that these I have inspected, I've gone through these machines, or I've gone through the factory or whatever it is, and I find the following deficiencies. The other side, on the other side, will probably engage another architect or another expert who would assist them in cross-examining this material. Now, you'll have to make a test. When you're cross-examining an expert, what are you going to ask? And when you're asking something from a claimant, what are you going to ask? To give you a very example or very fundamental. In a case before a court on landlord and tenant, the tenant raised the issue that I always paid him by cash, all rent, all through. He would sometimes give me the receipt, sometimes he would not give me the receipt. And when he gave me, I have done. When I did not give, I did not insist on it. So in cross-examination, those receipts which were issued by the landlord were put to him, and he accepted them. So question was asked to him that there is a receipt of January, then there is a receipt of May, then the receipt of December. There is no receipt in between, and you have not claimed this money. That means they were paid to you. He said, yes, they were paid. That's the end of the cross-examination. You don't need to ask any other question. Because that's the case of the tenant. that I used to pay him cash. Sometimes he used to give me receipt, sometimes he would not give me receipt. So question is, you will have to learn the art to lead evidence. In fact, to lead evidence in affirmative when you are asking your own witness to depose is much more difficult than even cross-examination. Because cross-examination will go haywire also, there's no problem. But not, you can't ask in leading questions, for example, in your examination chief. So the challenges before you as youngsters are that we must, what we have started looking at, we just put our laptop on and look at SEC online and see what are the judgments, who has delivered the judgment, that's all. And then we say, Mr. So-and-so, and recent phenomena, last 4-5 years, I think. We now quote judgments in our statement of claim and statement of defense. Judgments can't be quoted. Judgment is given in the context of that case. It may apply to you, it may not apply to you. So avoid putting that judgment. Put your specific facts, which in your opinion are the bundle of facts which will prove your claim before the arbitral tribunal. Similarly, the defense will put its defense, those factual assertions which will, if proved, would destroy a statement of claim. That's a simple situation. So once you know that what you have to put in, then you apply your mind to do that. And to give you on a lighter vein an example, a recent matter was sent to me for opinion. And on the top of that, it said important judgments are in Annexure A. So I was wondering if there is judgment, then why do they need my opinion, first of all? But anyways, I just turned over all the pages and I saw Annexure A. 7-8 judgments I could remember by name. And there was nothing to do with the subject matter for opinion. So I called up the solicitor and said, brother, you don't need this judgment. What are they? There's nothing to do with this case. He said, sir, I'm sorry, sir. Actually, I gave it to my intern and he just go to whatever you call ChatGPT or whatever you call. He just copied it from there and sent it to you. So please don't do that. Law is not, yes, I agree. Precedents are important. Precedents help you lay down the law. But I, for one, would suggest to youngsters, from those departure, make a departure from them and bring something new. Maybe you can bring something new better. Then that will be precedent. So you should target to see how many precedents you create, not that what precedents Natha Singh or Prem Singh has created. No. Make a target, make that as your zone of consideration. That I shall, in my arbitration proceedings, bring this as a precedent. I appreciate that the arbitration proceedings are confidential. But if in confidential proceedings are otherwise went to court for enforcement, or a petition is filed to set aside that award, then there's no confidentiality involved. Court is in public domain. I can't say I'm arguing an arbitration act, so everybody should go out to the room of the judge. No, it can't be possible. So yes, those proceedings are confidential. I agree. And now see, let me bring in a point here so that I can make it clear. When you are doing mediation, and supposing in mediation, Keshav brings something, I bring something, which we are doing with an aim that we may be able to resolve the matter, that evidence, both of us are barred from bringing it in the court. That's confidentiality. But the award as such doesn't become confidential, especially with respect to the judgment or the award that is made. Ultimately, you go to court either for enforcement or for setting aside or for both. So to that extent, there's no confidentiality. Of course, arbitration, they all say, is confidential. But unlike mediation that I gave you an example, arbitration would still have that. Now, mediation settlement also comes to court, unless it's a outside court mediation. It will still form part of the court record, and I and you can get a copy of it. So where is the confidentiality? Confidentiality is the process of mediation. What transpires during mediation is confidential, not the mediation settlement as such. So therefore, make that distinction to see what you have to learn is A, fundamental principles of code of civil procedure to make your statement of claim. So code of civil procedure, what we talk there, a written statement, what you will put as a defense or SOD. You will have to make points of determination. There's a provision today which is coming up, though it's only at the paper at the stage where the government is consulting all experts to see whether we can bring emergency arbitrator, a focus into it, a new statutory provision, which probably we'll see when the parliament passes that. But as of today, there is no such provision. There is another confusion that is coming up, that I am before a tribunal of a single arbitrator. Parties, arbitrator makes a remark, why don't you both sit down and resolve it? And we both say, sir, you become the mediator. So if he's a mediator, then he's barred. He can't adjudicate further. Because during mediation, he has come forward, he has seen the two persons' confidential documents, other things, which he cannot keep in his mind while making an award. So he's just debarred. But I've seen many times people say, no, sir, we have no objection. You continue. And they continue also. But here there is an ethics situation to my mind. Notwithstanding parties agreeing, I as such should say, no, sorry. After having mediated in a settlement, I would not like to adjudicate upon it. Because I'm a human being, I'm not a god. So that bias or whatever I have in mind will always creep into my award. Therefore, question today is, you have no challenge if you ask me. There's no new challenge in 2024 that has come, except that, yes, law is amended. Those amendments, you'll have to look at it. We had 1940 Act, where award had to be brought to court to become a decree. 96 changed the whole phase. The award itself became a decree. So these are changes in situations. The law is amended. In fact, this act has been amended in 2015, 19, 21. And we are still having those papers. Let's see when those new amendments come. So earlier, we did not find a situation where there was a situation where arbitral tribunal can't charge more than this. Today you have scheduled to it. There is some eligibility criteria now provided in the Arbitration Act, which was not there earlier. So these changes I must look at to see how does that develop, how does that affect, or how does it come handy in your hand in an arbitral tribunal. So supposing there's somebody's brother is sitting, or somebody's attorney is sitting himself as the arbitrator, obviously you don't expect. So, I mean, there could be people who, notwithstanding that position, may be able to do justice. I'm not saying that. But justice not only should be done, it should be deemed to be, you must see it done. No? So the conflict is apparent. So if you know about this, then you will be able to raise that objection even at the time of appointment, or even thereafter, because it's not eligible. And we have now brought a new timeline into the arbitration also, which is not there in the Code of Civil Procedure. An arbitral tribunal must finish his pleadings within 6 months. He must complete his arbitration within 12 months, plus another 6 months. And thereafter, you can't extend. And you see, the unfortunate part, what is coming is this, that in a given case, the court takes a view, all right, I'll condone the delay. If the statute says you can't have it, then how can you condone the delay? But yes, I appreciate they feel that one case is at least finished, parties have spent more money, because the arbitration is costly today, there's no dispute, except for institutional arbitration. The ad hoc arbitration is costing a lot of money and people are apprehensive. In fact, the government has taken out a circular today, in the last few months, where they said you, beyond 25 crores, you will not go to arbitration straight. You will go to mediation. Because they found the cost of the arbitrators were so much that apart from the claim that they would have to pay, the cost of the arbitration was maybe twice the amount there. So what is happening today is this, that our youngsters must look at this part. If you look at and follow the request that I'm making, in the manner in which I'm suggesting to you, with whatever modifications you want to do, it's not that whatever I say is pathar pe lagi. Everybody has his own way of looking at a case. You may look at a judgment differently, I may look at it differently. Keshav may look at it differently, somebody else may look at it differently. but adopt it. The fundamental principles will remain the same, whether I do it or you do it. So in that way, there's no distinction between, except the fact that I have white hair now. You may having black, but the eyes are the same. I will read the same statute that you are reading. In fact, your brain is fresh. I will still be biased with something that is in my head always. But you may use your fresh brain. You are a youngster coming now, interpret that statute. You may be able to say, yes, this provision means this. You have an arbitration which says, Section 9 says, if the arbitral tribunal is not constituted, there will be no arbitration. Then what happens to the agreement? Does it die its death? There is no. You will only dismiss the interim relief. The arbitration still remains. So what we do, we say so and so versus so and so. Dr. Amit versus Mr. Chandhiok, it was held. He has not invoked the arbitration. Therefore, the arbitration goes. Arbitration doesn't go. Your interim relief under Section 9 goes. And therefore, the necessity is that we need to look at all these aspects. Then brings me to other aspect, which is the greatest challenge then is when you have an award. The enforcement becomes a difficulty. The setting aside becomes another difficulty. Because if you see Section 34 of the Act, subsection 1 and subsection 2 are distinct from each other. First subsection compels you, as a person who is challenging that award, to show to the tribunal why the award is bad. While the second subsection obligates the court, with the arbitral court, to see whether the award is in accordance with law. So, before Section 29A was inserted by the Act of 2015 or thereafter amended by 2019, a question arose before the arbitral tribunal that everything finished in 2019, but the award came in 2024. So then the arbitrator was thinking, my God, the Supreme Court has extended the time. So the question was, how much time is extended? So these little things will become something new for you to interpret. And ultimately the court said, sorry, he would have forgotten what was argued in 2018-19. How does he remember in 2024? And therefore the award is bad. Till we, of course, in 2015, we got the amendment also, 29A. Now 29A, when was inserted, had Section 26 in the Amendment Act, which said it will only apply to arbitrations after this date. Then it was amended in 19. They brought that 26 into 87. 87 was struck down by the Supreme Court. So there's no bar today. But we still go back to 2015 and say, no, 26 was there. Well, something very small. 26 never became part of the main statute. It only remained in the Amendment Act, which nobody brought to the notice of anybody. So you as young mind will be able to remember that and point that out. To say, sorry. And something which has come to my notice day before yesterday. In an application filed by a shareholders dispute, lender and borrower with a guarantor or pledger, Section 17 was filed by the pledger to say, you will not sell my shares. The arbitral tribunal said, yes, you can't sell it. Subjects, battery subjects. But then they say, all right, you may sell these shares, but what caveat? That if the claimant was to succeed in the arbitration, then you will have to buy shares and give it to him. The first principle of restitution. But when the award comes, the arbitral tribunal itself forgets it. That I passed that order. It says, no, I can't give you that relief. He holds the other side is bad. He holds that they had no right to sell. He holds there was no default. And judge says, I can't give you anything. Then why did you pause that order in the interim? Now, these little things you need to understand and grasp, which many of us miss. And that is where our decline in arbitration is coming, though we have tried to bring it up now. what we used to get 3-4 years in getting a petition disposed of in the arbitration. Fortunately, in Delhi, we have reduced that time lag to about 12 months, 14 months. Sometimes even in the very admission, it goes out. Enforcement has taken good developments now in enforcement also. Now, a question is arising for you to consider now, youngsters, that I have an award against the foreign company. Foreign company has no assets. I file an execution, he says I have no assets. Court kya karegi? We can't execute anything. So what will be the remedy that you have? You can't go to China or somewhere else to execute it. The cost itself will be more than the award that you have got. So you must develop a principle to tell the court, like we have in the principles of Order 41 Rule 5. It's a money degree. For execution, he has nothing here. So direct him to deposit money before he can be heard. Now, these are new principles that you must look at. These principles must tell you how you're looking at with them. How will you want to develop them? And how will you engage the arbitrator? So that's by far your challenges. I don't think, really speaking, Keshav, there's any challenge. The challenge is only one. How do you get your facts in? How do you get the scheme of law? And once you have both, then I don't think there's any dispute. Thank you very much. I'll answer questions if there is.
Certainly. So I'll just disclaimer to everyone, kindly just share your questions in the chat box right now. Or just raise your hand for whatever questions you want to ask. I am certain that whatever questions you are there, sir is kind enough to take them. In the meanwhile, sir, I'll just most humbly try to take out some points that I could figure out from your.
Sure.
So one, so very interestingly, you mentioned about treaty arbitrations, and you mentioned dispute arbitrations. So, sir, similarly, what are the kinds of arbitrations which are there, and just a little description about them,
There
if
could
possible.
be an arbitration between a claims between husband and wife, not the divorce, but claim, because in many parts it could be joint properties, it could be joint assets. So you have an arbitration clause to decide those disputes, one kind of domestic arbitration. There could be arbitration where I have sold goods, goods are not according to description, so it is Sale of Goods Act. Or I had given them a warranty that these goods will be fine for 2 years, but they've gone bunkers in between. So there will be nature of dispute will be different. So though it's commercial, but even in commercial, there's some commercial, I can call them loosely. Because you don't know what you have an immovable property, which is leasehold. Then the question would be, can you partition it? The answer is no. But you can partition the superstructure on it. It's another nature of arbitration. So the only exception we have made is trust you can't arbitrate. Agreed. You can't arbitrate a will, as a probate court can only do it. So those are exceptions. But from a mere commercial dispute from a shopkeeper to a big house, it may have various disputes. It may have a dispute between him and his contractor. He may have a dispute because today labor is, people don't employ, they get it from contractors, their labor. So there could be dispute that the labor has not been paid. Therefore, you are the principal person who is responsible to discharge that debt. So he may make a claim against you. So there could be nature of dispute, could be immense. I don't think I can even specify them into 1, 2, 3. But yes, as you rightly pointed out, there will be a distinction between a treaty arbitration, where the country has taken steps as a country, as a sovereign, to ensure that claims made by B country's people are not entertained. Yes, that's a treaty violation if I have a treaty. But simple investment into the country, and that doesn't, I came to this country thinking I'll make 30% or 50% profit, I'm not making it. Doesn't mean treaty is violated. It's a commercial matter. So you will have to, that's why I'm requesting the children or the youngsters must make a distinction. What nature of arbitration am I doing? Am I doing a simple arbitration? Am I doing a treaty arbitration? Am I doing an international arbitration? Because there can be international arbitration with seat in India. It's not necessary that you should have a seat abroad. Normally, when people say international, we start feeling like in London hoga, Hong Kong hoga, Singapore hoga. No, today you can have it in India also. It's not that. Therefore, the need challenges this only, that I must ascertain what is the nature of my dispute and then see what is it. So these are various kinds of arbitration that we may have.
Certainly, sir. Thank you so much, sir. So there is this question from Mr. Dhananjay Gupta. Dhananjay ji, please ask.
Gee.
Hello, sir.
Hello, sir. How are you?
I'm good, sir. All your blessings, sir.
Gee.
Sir, there is one simple question of mine with sir. There was a Section 9 petition in which an interim order was passed. Thereafter, arbitration took place, and in between, the one of the party said that the interim order that was passed by the Honorable Delhi High Court should be set aside because of so and so reason. The arbitrator declined. Now, what happens? This is all pre-amendment, and the one of the party passed away the order of the arbitral tribunal as well as the High Court order before arbitration, before amendment. Now, the question that is posed to me is that, yes, so whether the pre-amendment, the contempt that has been committed, firstly, that where does the contempt petition will lie? It will lie before the Honorable High Court of Delhi, or it will be filed before the tribunal. One thing that the issue that I am facing, and whether the amendment will have any effect to it or not.
Two questions for me to answer.
Yes,
I can split up their question. If there is a event which has taken place prior to Section 17 being amended,
yes, sir.
The order was passed by the arbitral court, which is the High Court of Delhi.
Yes,
the
sir.
contempt has to lie in the High Court of Delhi. One.
Okay.
So the second limb of your thing, that I move the tribunal to set aside, unless the High Court had said this would be treated as a petition under Section 17, the tribunal will be entitled to modify it if he so likes. He has no jurisdiction to deal with it. The High Court alone can deal with it.
Okay, sir. So what I'm able
The tribunal will have no jurisdiction. Yes, if the High Court, while referring the matter to you or deciding section, that order is being passed, however, the tribunal on a motion being moved will be entitled to take a view, modify, confirm, or whatever it wants to do.
Okay.
Then only the tribunal will get the jurisdiction, not otherwise.
Not otherwise. It will continue throughout the
To be the order of the High Court only.
High Court order. Okay, so the contempt will lie to the High Court.
High Court only, yes.
Reason being the order was passed by the High Court.
High Court, that's right.
Okay. Irrespective of the amendment.
No, the amendment doesn't take away the jurisdiction of the High Court.
Okay, sir. And sir, apart from this, sir, may I know with regard to the contempt, initially before the pre-amendment, this is what the understanding of mine is. If there is a violation of Section 17 order, then the arbitral tribunal has to refer the contempt to the High Court. Then,
that's right.
After the amendment, Section 17(2) was added to give teeth to the Section 17. So now if any contempt is committed, so the contempt will lie to the tribunal, or it has to be again referred to the High Court.
Very good question. Now please see your district court.
Yes, sir.
You commit a contempt in the district court. The district court looks at it whether it's a contempt made out or not.
Yes, sir.
Then refer the matter to the High Court for decision. The
Yes.
jurisdiction under the Contempt of Court Act is only with the High Court, not with anybody else.
Okay, sir.
So the tribunal will prima facie look at it, whether contempt is committed or not, and send it to the High Court.
Sir, if may I, so then where does the distinction lies? Then it has to be referred to the High Court.
Well, because otherwise, tribunal has jurisdiction, but where will he get the jurisdiction today? Read 17(2) with me. You have 17(2)?
Yes, sir. Yes, sir.
As
I
you
will
so
read it together.
Sir,
That's why I said you will have innovative mind.
yes, sir. So may I read?
Get the read.
Subject to any orders passed in an appeal under Section 37, an order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure 1908 in the same manner as if it were an order of the court, sir.
So what does it mean? It means earlier, prior to this amendment that you saw, which you're reading in subsection 2.
Yes, sir.
First is right of appeal. First part goes.
Yes, sir. 37 years.
Okay. Any order issued by the arbitral tribunal under this section shall be deemed to be an order of the court for all purposes shall be enforceable under the CPC. That's all. So it's the enforceability. Some orders passed are enforceable. Take, for example, 39(1) and 2.
Yes, sir.
Some orders are enforceable.
Yes. Okay, okay. So they are...
The court was to say, Mr. Chandhiok, please give me a bank guarantee. And I don't give.
Okay.
You have a right to go to the executing court and say either he gives a bank guarantee or attaches account.
Okay.
Therefore, those orders are enforceable.
Okay.
So it is only giving teeth that they will be again enforced under the CPC where contempt is coming here.
Okay, sir.
In subsection 2, there is no contempt.
No, sir. For instance, no, now it goes back to section 27(5). Now,
let's see 27(5) with you.
Yes, sir. (27)(5), sir. So 27 says court assistance in taking evidence.
That's
and
right.
5 says persons failing to attend in accordance with such process or any other default or refusing to give their evidence or guilty of any contempt of the arbitral tribunal during the conduct of the arbitral proceedings shall be subject to the like disadvantages, penalties and punishments by order of the court on the representation
A fiction is created. A legal fiction is created. कि अगर अब ट्रिब्यूनल का ऑर्डर भी आप वायलेट करेंगे, आपको वही आपकी हालत होगी जो आप कोर्ट के ऑर्डर को वायलेट करते हैं. पर क्वेश्चन आप जो रेज कर रहे हो कि ट्रिब्यूनल कंटेम्प्ट में उसको खारिज कर कैसे कर देगी? नहीं, कंटेम्प्ट मतलब द पॉइंट इज कंटेम्प्ट. मैंने वही तो आपसे पूछा. क्वेश्चन आप सीधा जाओ. आपने डिस्ट्रिक्ट जज के सामने या सब जज के सामने कंटेम्प्ट फाइल हुई, आपने 39(2)A फाइल कर दी. वो ये प्राइवेट से होल्ड करेगा ना कि कंटेम्प्ट में हो और रेफर कर देगा हाई कोर्ट को. ओके. रेफर टू द हाई कोर्ट.
धनंजय, बाकी के गाइडेंस के लिए एक बार हाई कोर्ट में मिलना पड़ेगा बैठ के ना, कॉफी चला और बाकी एक रेज्यूमे बना के सर को आप भेज दो इस बीच में. मुझे लग रहा है कि काम आधा हो चुका है.
So kind of you, sir.
And I'm sorry for interjecting, but actually there's a time limit which we have.
Yes, so sorry to extend.
So I got back into the court. मैं तो फाइल ढूंढने लग गया था. मैंने कहा let's come back to where's the Conciliation Act. निकालो arbitration. So again, sir, before I get carried away, so there is one question from Miss Ambreen Khurshid. Ambreen ma'am, please ask.
So I have a question. So being young practicing advocate, so how to make a career in arbitration?
I think what I was talking about only this, that how do you make a career? How do you make a career in court? You work. You see, you should be known in your arbitration field. Arbitration is what? That's why I said today the scope of arbitration is much larger than what we used to think. I just gave you an example that between husband and wife there's a joint property. Divorce has taken place. What happens with joint property? So many of us don't look at section 27 of the Hindu Marriage Act to ask that additional district judge that you can please adjudicate on those joint property. We said divorce ho gaya, cholo. Now, property to joint rahegi na. And supposing in that you enter into an arbitration agreement, then you will go to an arbitral tribunal. So your career that you are making is by going into those areas where arbitration is the foray, like commercial disputes. like disputes within building contracts, for example. They're all arbitration. So once you start moving in that direction and you're found that you are doing arbitration, your career is made. 10 awards by your assistants are not satisfied by the court. People will start recognizing you. And please tell me, I must tell you, read this first fundamental question. Supposing there's a dispute between me and Keshav, and you are representing Keshav, and you have throttled me badly in that case, which I'm sure you will do. If next case do I have, I'll engage you straight away. That's the building practice. That's the career building. Because we can't advertise, we can't tell people, look, I am an arbitration lawyer. No, nobody can do that. So far, I don't know what will happen. So therefore, with the situation changing is that you should be seen to practice in that branch of law. How people go only to family court, to those few lawyers who done only family matters, because they are seen there. So you should see whether it is, for example, NHI have all arbitrations, minus the new circular that has come. Every public sector undertaking will have arbitration. Every contract between even a small builder has arbitration. So if those cases are being seen, handled by you, then I don't think there's any problem at all. There's nothing else. I can't suggest you start giving Hindustan Times an ad that I'm an arbitration lawyer. You can't do it.
So, Amreenji, I hope that answers your question. Is there anything that you want to ask with respect to that in furtherance?
No, sir, thank you so much. I got my answer.
And you have your community with you. Go to your community and say, all arbitration should come to Amreen. Will you get them?
सर ये सर कम्युनिटी क्लासेस सर यही हमारी कम्युनिटी है सर इसका ही आशीर्वाद इस पे आप दीजिए कि
No, therefore I'm talking about this very community. I'm not
हाँ
talking
कि ये
about the
नहीं
community.
मैं इसी की बात कर रहा हूँ कि सर यही प्रॉस्पर होती जाए कम्युनिटी क्लासेस द
Yes.
एंटायर आइडिया इज
There's nothing to do with caste, color, and creed community. I mean, you will, if I know Reen is a person who does arbitration and I don't go to arbitration, I'll send it to her.
No, sir, absolutely, sir. But sir, I also do, sir. Please, you can send it to me also. Just casually, sir, in lighter way.
Sure. Why not?
So, a follow-up question actually I have with respect to Amreenji's question. This is with respect to domestic arbitration. I think you've very elaborately expounded. So there is one answer. This is a relatively, how do I say, ambitious aspect that I want to explore. Why I'm asking this. That's what exactly is international arbitration? In very short, sir, because we've already taken up your time. In very short, sir, what exactly is international arbitration? And if, in furtherance to her question only, if someone wants to go into arbitration, let's say, should they join an office? Should they join?
This in any case, let me put it straight away. Any youngster who wants to even join only arbitration, please go to court at least for 2 years. Because the principles of law, jurisprudence is the same. You should learn how the courts function. You will then see how it is different to function with the before and after tribunal. Go to somebody's chamber who does only arbitrations or majority is arbitration. Then you will assist him or her and then you are known in the field. That's where your career building. But there are people who does less domestic arbitrations and international arbitration more. Those of us who are registered with, for example, Singapore Arbitration Center, they will get commercial disputes or international. So international dispute is already defined under law. One party is abroad, one party is Indian, the international बन गया. उसकी seat देखो कहाँ है? Seat is in India or maybe Singapore, maybe London, maybe Hong Kong. So all those things, when you start moving in that direction, when people start looking at you, what happens in court? A youngster coming to court, he appears in court and he sees, he appears with Keshav. Keshav is doing a particular matter and that youngster is every time telling Keshav, do this also, do this also. So somebody is watching him. That's where you increase your practice. So you have a lawyer has to be prepared for every eventuality. all windows and doors are open for it. There's nothing closed. And then move forward.
So kind of you, sir. So grateful to you, sir, for all of this. So just one final thing I want to ask you. So there's a little off context. So you mentioned that there is some event which is happening on 11th of
No, this is
January.
an event. What we did was that we have, if you all will probably recall that great lady, Sadhana Ramachandran, was a great mediator. She, I think, especially matrimonial and disputes between families, she single-handedly did a lot of. She sat in the mediation center till late at night to resolve those disputes. She had the privilege of settling a dispute between husband and wife who were divorced and got them married in the center and sent them back. So, unfortunately, we lost her after she developed cancer. She fought that cancer for 10 years, but then we lost her. So, this is now Sadhana Ramachandran Madhyam's ADR learning, where we pick up topics. Like I've just given you an example, a distinction between 34.1 and 34.2. And when you see that proviso at the end, which the legislature now added, it will also apply to, supposing it is saying arbitral tribunal की गलत बनी है, तो proviso कहाँ से आ गया फिर? Proviso will only apply to subsection 2. So these distinctions we are wanting. Therefore, first question is that. The second question topic that we have put in is that I am the person who's agreed by an award. I filed 34. Can I also file a section application under 34.4 to say, please resume the arbitration proceedings? Or should the other side only do it? And the third I've already given to you, that where the award set aside by Delhi, the question whether the seat changes or not. So these are very, this I think probably the full day cost, everything with lunch, everything is for 2,000 rupees or 3,000 rupees. So really speaking, we are wanting to educate on these ticklish subjects to our youngsters. And that's where it's on 11th of January at Habitat Center.
So I request everyone kindly, please, these are very interesting
please,
things.
you can get in touch with me and I'll put you there. There's no problem.
And absolutely, guys, it's most important. And anyone who's wanting to build their practice in and around arbitration, please just reach out to sir. He's always very kind, and try to attend all of these functions. I also got to learn a lot from sir through one such function. So I think, sir, I'm just grateful to you for this particular bit. So just one other thing, absolutely outlandish, that I want to have a conversation with you. Just one question that I want to ask for you. For what are the challenges or what are the opportunities that young lawyers, and so because this is an absolutely different topic, so just a one-line thing for everyone
So
to
your
keep in mind.
opportunities are how much you put into that, brother. I don't think there's any yardstick, any staircase that I can show you. That's why I said if you want to go to only arbitration, join a chamber. First go to court for a year or two. You will know the details of that. Then go to a chamber which does arbitration as majority. You will learn the inside out of arbitration. And when you start working, you would start with maybe with a, let's say you go and approach that Hindustan Mercantile Association, which is in Chandni Chowk, which is a small thing. You will start with small arbitrations and go forward. And then there are trainings that you undergo. Once you undergo that training, then you can get yourself registered with Delhi Arbitration Act. There's a FICCI arbitration. So many arbitrations there. Once you join them, you'll get work automatically.
Great, sir. Great. I think all of these small points, nuances, I request everyone to kindly just take these points out, and I'm absolutely certain that everyone will greatly benefit from all of this, and definitely arbitration in the future. And sir, I think you mentioned somewhere that arbitration something declined or something. So what you guys are doing, sir, that's
declined. You see, the reason being my fee is so high. So obviously people are now scared.
Certainly.
I have a claim of 20 crores. If I have 6 crores, I have to pay to arbitral tribunal. I might not give it.
So for startups and for small companies, so what is the scope of arbitration?
lot of scope, because you see, that's what I'm saying. Arbitration is a party autonomy. Na? Those parties which are not wanting, they should need not talk about anybody. They say, I'll go to Mr. Keshav. They'll go to Mr. Gagan Garg, who's saying thank you to us. So it's a party
जी सवाल
autonomy.
भी
You may
पूछना था
both
ये
agree to
thank
chat.
you बोल के
You
नहीं.
may both may say, okay, he is one person who will decide it. So there, what are you doing? You are doing three things. One lawyer is coming for the claimant. He understands no arbitration. One coming for the respondent is also understanding arbitration. And the third is the arbitrator himself. And your cost has come down. So I am only saying probably the government is thinking that, they have suffered so many awards now against themselves. And the cost has been very high. So therefore you say that looking at the cost, I may not look at it. That's a little disheartening situation. Because if we are looking at making India a hub in the arbitration, then we can't do this.
Sir, it will be, sir, with you guiding us.
I'm sure it will be done with all of
make it
you
happen.
there, with all these efforts that you are making. Thank you so much for.
So it's just very humbling and very, very kind.
Thank you. Thank you so much. Thank
Take
you so
this opportunity. You give us so much love and so much knowledge. It's just, how do I say, it's truly, truly remarkable, sir.
Thank you so much. Thank you so much.
Deepest
God
gratitude.
bless you all. Have a great evening.
Wish you the best, sir.
A great Friday. Have a good weekend.
So we have classes, sir. Actually, so this entire weekend we have classes. We have classes from today till the 24th. That is when the Delhi High Court closes.
Wow, very good.
So,
And
sir,
they can celebrate their Christmas thereafter well.
sir, sir, आपका आशीर्वाद से पक्का. I'll try
नहीं
to.
होना चाहिए, बिल्कुल बड़ी अच्छी. It's a very good thing that you started.
Very kind of
Great
you.
initiative, I think. Great initiative.
Very kind of you, sir. Thank you so much, sir.
Thank you so much. Thank you so much. God
Thank you
bless
so
you.
much. So,
Thank
sir,
you.
with your